Job design and job redesign are incredibly powerful HR tools. When done well, they can elevate productivity, streamline processes, and truly improve the employee experience. But effective job design must also be grounded in the law. As HR professionals, we are responsible for ensuring that the roles we build not only help the organization thrive, but also uphold fairness, equity, and safety. In this lesson, we are going to walk through the major U.S. laws that shape how jobs are created, structured, and maintained. These laws protect both employers and employees, and understanding them is essential to ethical and compliant HR practice. Legal issues in job design typically fall into a few major categories: equal employment opportunity, compensation and benefits, and workplace health and safety. These aren't just abstract guidelines. They affect the everyday decisions HR makes about job descriptions, required skills, working conditions, and employee expectations. Having a strong understanding of these areas sets the foundation for responsible HR leadership. One of the most influential laws impacting job design is Title VII of the Civil Rights Act of 1964. This law makes it illegal to discriminate based on race, color, religion, sex, or national origin. And that protection extends to the way jobs are written, advertised, and assigned. If a job description suggests preferences or eliminates candidates based on one of these protected categories, the organization is in violation. Title VII also covers sexual harassment, reinforcing the responsibility employers have to maintain safe, respectful work environments. This law applies to a wide range of employers, including private companies, government agencies, and educational institutions. Another key law is the Age Discrimination in Employment Act, which protects individuals age 40 and over from discrimination. This affects job design in subtle but important ways. Requirements must relate directly to job performance, not assumptions about age. Many states and local governments have gone even further by adding protections for sexual orientation, gender identity, marital status, family responsibilities, political affiliation, and more. As HR professionals, it is our responsibility to stay informed about additional local laws that may affect our workforce and ensure our job design practices reflect those protections. Two other important laws directly influencing job design are the Americans with Disabilities Act and the Pregnancy Discrimination Act. The ADA requires that job duties, descriptions, and work environments provide reasonable accommodations for qualified individuals with disabilities. This means we must separate essential duties from non-essential ones and ensure the role is accessible. The Pregnancy Discrimination Act reinforces that pregnant individuals cannot be excluded, penalized, or disadvantaged through job design. It also protects their right to return to the same or equivalent job after maternity leave. These laws remind us that job design must support access, equity, and long-term career continuity. Job design also intersects with compensation, and that's where federal labor laws come in. The Fair Labor Standards Act outlines rules around minimum wage, overtime, and job classification. If a job will require overtime or non-traditional hours, that must be communicated clearly. The Equal Pay Act and the Lilly Ledbetter Fair Pay Act reinforce that employees performing equal work must receive equal compensation, regardless of gender. These laws emphasize that job descriptions must accurately reflect responsibilities because those responsibilities influence exemptions, pay decisions, and compliance. Beyond hiring and compensation, several major laws guide how organizations handle benefits and employee protections. The EIRSA law outlines roles and responsibilities related to employer-sponsored retirement plans. FMLA guarantees eligible employees up to 12 weeks of unpaid, job-protected leave for major life or medical events. So job design must allow for continuity when someone steps away temporarily. COBRA requires employers to offer continued health insurance coverage for employees who resign or are terminated, ensuring a smoother transition between jobs. HIPAA protects employees from losing coverage due to pre-existing conditions and ensures their medical information is treated with confidentiality and fairness. These laws shape everything from onboarding to offboarding, and they influence how HR designs roles that support long-term employee well-being. We also have the Occupational Safety and Health Act, which defines federal standards for safe working conditions. This law plays a major role in job design for physically demanding roles involving specialized equipment, or environments where hazards are possible. Employees are also protected by whistleblower laws if they raise concerns about unsafe tasks. This underscores the importance of designing jobs that are not only efficient, but also safe. In unionized workplaces, the National Labor Relations Board supports employees who raise concerns about job duties or working conditions. Many states are also moving toward anti-bullying and anti-harassment laws that reinforce respectful, professional workplace cultures. Job design must account for these protections by ensuring roles are safe, fair, and appropriately structured, and that employees have avenues to raise concerns without retaliation. Another important concept is employment at will. In every state except Montana, employees and employers can end the employment relationship at any time for almost any reason, as long as it's not discriminatory or retaliatory. This doctrine affects job design because it influences how job expectations, termination procedures, and contracts are written. HR professionals must design roles and policies that align with this doctrine while still maintaining fairness and transparency. I know this is a lot to absorb, but these laws form the backbone of ethical and compliant HR practice. They have shaped American workplaces for decades and continue to evolve as society changes. Staying up to date on legislation isn't just a best practice, it's a professional responsibility for anyone working in HR, especially those involved in job design and workforce planning.